Good day, colleagues. Welcome to another episode in our What If series, where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I am Ross Simon from Maserumule Corporate Employment Law, and in today's episode we will unpack what if an arbitrator finds that a dismissal is substantively unfair. Does the arbitrator have to reinstate? What are the legal considerations and implications? The case discussed in this episode is the matter of Nortisi versus SAPS and others. In summary, the facts were that the appellant employee was employed by the SAPS as a colonel. He was charged with 2 charges of misconduct, namely perjury and interference with the administration of justice arising out of his alleged conduct during a criminal prosecution of members of his team who were charged with very serious acts of misconduct. The appellant was found guilty of both charges at the internal disciplinary inquiry and was dismissed. He referred an unfair dismissal dispute to the Safety and Security Sectoral Bargaining Council, which found that on the totality of the evidence, the SAPS did not prove on the balance of probabilities that the appellant was guilty of the charges. As a result, the arbitrator concluded that the dismissal was substantively unfair. Because of such findings, the arbitrator deemed it unnecessary to consider the appropriateness of the dismissal sanction. The arbitrator ordered reinstatement together with back pay. Disenchanted with such an award, the SAPS launched a review application in the Labour Court. The review application was based on the grounds that the arbitrator misconstrued and ignored the inconsistencies in the appellant's evidence, and therefore the award was unreasonable. Further to that, the SAPS contended that the reinstatement remedy was inappropriate because the trust relationship between it and the appellant is irretrievably broken down. The Labour Court on review agreed that the dismissal was substantively unfair, but found the order of reinstatement to be inappropriate on the grounds that the trust relationship between the employer and the appellant had irretrievably broken down. The court concluded in overturning the order of reinstatement and replacing it with an order of 12 months compensation, it was impossible to avoid the conclusion that the trust relationship was seriously damaged, or alternatively, that the appellant's conduct was incompatible with his functional role. The court's finding of intolerability was unrelated to the disciplinary charges against him, but was instead attributed to his alleged failure to adequately investigate and disclose pertinent information to his superiors in regard to the criminal prosecution that took place. The Labour Appeal Court was divided on the issues of the appropriate remedy to be awarded. The minority was of the view that the employee's conduct that preceded the criminal prosecution of his colleagues and his conduct thereafter militated against reinstatement relief, finding that it would have not been fair to expect the SAPS to continue an employment relationship with the appellant. It was noted that the breakdown of trust or intolerability in an employment environment, especially a government employer like the SAPS, must not be viewed from collegiality perceptions, but rather on the broader image of the SAPS, and in this case, the public expectations on how members of the SAPS should conduct themselves. The majority noted that the Labour Court had erred in failing to recognize not only that the bar of intolerability is a high one, not easily reached, where the employer required to provide weighty reasons with tangible evidence to prove it, but also that such evidentiary burden is heightened where the dismissed employee has been exonerated of all of the charges. The majority pointed out that the Labour Court had deprived the appellant of reinstatement for alleged misconduct which had not been charged or disciplined. The majority concluded that to punish the appellant in such circumstances with unemployment without having been found guilty of any wrongdoing was grossly unfair and unwarranted. It is the duty of an employer to present reasons and tangible evidence to suggest that the continued employment relationship would be intolerable. However, intolerability is a matter for the court or arbitrator to determine when exercising their discretion, based on the conceptions of fairness and not merely a matter of the parties' pleadings. Accordingly, the majority found that the appellant was to be retrospectively reinstated. Section 193(1) of the Labour Relations Act provides that the Labour Court or an arbitrator to order an employer to reinstate or reemploy or compensate an unfairly dismissed employee Section 193.2 stipulates that the labor court or arbitrator must require the employer to reinstate or reemploy the employee as a primary remedy. The norm, therefore, is to order reinstatement, and the denial of that primary remedy should only occur as an exception. The exceptions are identified in Section 193.2 as follows. The labor court or arbitrator must require the employer to reinstate or reemploy the employee unless the employee does not wish to be reinstated or reemployed. The circumstances surrounding the dismissal are such that a continued employment relationship would be intolerable. It is not reasonably practical for the employer to reinstate or reemploy the employee, or the dismissal is unfair only because the employer did not follow a fair procedure. It is clear, therefore, that the labor court and arbitrator must order reinstatement and should only deny reinstatement sparingly and after careful consideration of all the relevant circumstances. That brings us to an end of this week's episode. Thank you, colleagues, for joining us. We hope you found our discussion to be informative. If you have any questions or comments, we'd love to hear from you. You can find us on social media, or you can email me at ross@massconsulting.co.za. Until next time, bye-bye.